And I guess I've never asked for a sealed document, but it's public and public's public. I understand. She's 82. She suffers from many medical problems. In fact, she was hospitalized recently and she was just discharged, I was told by my client, on Monday of this week. So, Your Honor, defendant essay deposition I would ask for, and in the event that she's okay and able to come into court for trial, then we don't need the defendant essay dep. But I would like to preserve it because, again, she's another witness that's necessary for the case or the defense.
All right, Mr. Warren.
Thank you, Judge. I don't think there's been enough presented to the court here to determine whether there's an exigence necessary in this case to take extraordinary measures with this particular witness. I know Mr. Clovis put in his motion that he would provide the court in camera medical records. If the court wants to do that and reserve judgment, that's within the discretion of the court. The people don't oppose that. What the people are stymied by on this is the likelihood that what has been presented to the people is a phone call between the witness and the defendant shortly before the incident, whether or not that is relevant testimony in this case. The assessment of
Well, that's really not the issue.
right. And I guess the other argument that people would make is that there's video evidence of the defendant 20 minutes after the crash, that's the better evidence of the defendant's condition close to the crash as opposed to a phone conversation with a infirm woman some unknown period of time before.
May I reply, Your Honor?
Always.
Thank you. Again, the prosecution, just like the other witness of Dr. Gard, they're telling me how I should try my case.
Yeah, the relevancy issue isn't an issue for me because you're entitled to call this witness if you want.
Okay.
The question is she medically unavailable for trial? That's the question.
I can submit under seal or in camera the evidence that of her serious medical condition these days, not being made up.
So she lives at home. Is she mobile?
She's mobile, but as I understand, she does not see well. She had pneumonia. What else does she?
Macular degeneration.
Degeneration. She has.
I heard her. She said macular degeneration.
Thank-
That's the
thank
eye
you.
thing, right?
Thank you, Your Honor. And
But she's not in a wheelchair. She's not on a walker.
She has a walker.
She has a walker.
she's 82.
All right. Well, this isn't an unreasonable request. I have more information now than I did have in the motion. I'm going to grant this motion, but I'm going to put some restrictions on it. So the motion is granted, but this will be all costs borne by the defendant. And is this something that you can do in your office, Mr. Lorraine, like a conference room, that type of thing?
We could accommodate that, or if the defendant wanted to do it at some other site.
Well, here's what I don't want to do, spend 2 days arguing about where it's going to be. So we're going to settle that right now.
Your Honor, may I? We were thinking because of her condition, do it right at her house.
I don't know that the prosecutors necessarily want to go into a house.
Yeah.
Oh, okay.
And you're going to have to bring a court recorder in there.
Well, is this going to have to be a video?
Yeah, it's video.
Yeah.
I mean, I've done it many times.
Yeah, I don't think the house is
Oh.
is
All right. Well, I mean, we can do it at the prosecutor's office.
I think that you need to do it at the prosecutor's office.
Okay.
And I think it needs to be accomplished within a short period of time. So I'm going to give you a deadline. And then I guess if you pass that deadline, then if she's testifying, she's coming. Right?
Right.
All right. So let's do this. Today's what? The 17th.
Can I have maybe 2 to 3 weeks or at least?
Oh yeah, I was going to give you at least that.
All right. Thank you.
Want to make it the 10th, Judge?
That's
so
what
that
I
we
was
can
thinking.
report back.
Yeah, well, that was I was thinking. So we'll make it February 10th, which
Okay.
is the same day we're having the walker here.
And Judge, the defense is going to provide some sort of independent videographer or something like
Right.
that today. We're not just going to set up an iPhone.
No, I'm sure. Yeah, no, we're not, iPhone's not gonna make it.
Oh, no iPhones, Your
All
Honor.
right, I didn't think so.
All
all
right,
right.
thank you.
So our next motion is motion for change of venue.
Your Honor, what I would ask is this, is that this court, hold a hearing or evidentiary hearing where, people can be brought in to testify, not a line of people. We're talking about 2 or 3 people can testify, including the probation officer, that's, keeping tabs on my client.
It's not probation,
Not parole.
pretrial services.
Pretrial services. Okay, thank you, Judge. The pretrial services officer. But if we could have some sort of, the day you're doing the evidentiary hearing that's scheduled, if we could have, less than an hour to be able to provide proofs. And then I would ask the court, reserve till then and then make a decision, please.
Mr. Lorraine.
I don't mind doing that, but I think people are gonna stand by their position that at best, this motion is premature. That the case law supports that the court has to actually not be able to see the jury before it changes venue. I don't know what the testimony of 3 witnesses, that sounds like it's gonna be largely anecdotal, is gonna do to force the court to take the extreme position that things are so bad in Monroe County that it has to make a decision on venue right now.
They're hanging right behind us.
Whoever's talking, be quiet or I'm removing you. Response.
Oh, thank you, Your Honor. Your Honor, it's a rarely granted motion. But the law does permit it. This is a very closely knit community, and that's wonderful. But it's a very tainted, unfortunately, knee-jerk reaction that people have. And whether they're 100% loyal and honest, shall we say, and not have preconceived notions of guilt before trial, or you're guilty because 2 children, unfortunately, and I lost a child, 2 children passed, which my deepest sympathy is for those families. But Judge, it's just not going to be a fair trial. It's just not going to be fair trial. And I understand that it's rarely granted, but this is the picture perfect case for a change of venue. Thank you.
All right, thank you. So first of all, I don't see any support for having a hearing, and I'd agree with the people. You can bring in 10 people. I mean, it depends on who you bring in, whether or not they have preconceived notions. The bigger picture is the ability of this court to set and to find and seat a fair and impartial jury. Their exposure by jurors to media accounts of the crime, that doesn't give rise to a presumption that the defendant's due process rights have been violated or that she's entitled to a change of venue. She's got to show a pattern of strong community feeling against her. The publicity surrounding the case is so extensive and inflammatory that jurors cannot remain impartial once exposed to it. The people point out, and I agree with them, that the exposure in the local paper, for example, has been less than 1 article per month. There has been certainly some publicity around it. This is a tragic case, and there's going to be. But the question is, was the publicity surrounding the case so extensive and inflammatory that the jurors couldn't remain impartial once exposed to it, and that the jury was actually prejudiced, and that the atmosphere surrounding the trial created a probability of prejudice? And I can't find any of those things. While the coverage does detail some of the criminal allegations here, it hasn't been inflammatory. It hasn't been overly prejudicial. Sure, there are 300 comments on social media. I think most people don't read those, and half of those are trying to up the other person by saying something outrageous or ridiculous. A jury does not have to be consisting persons entirely ignorant of the case that they're about to hear. All the Constitution requires is that a jury be impartial, that it be one capable of fairly deciding on the evidence whether the defendant is innocent or guilty. Prosecutor points out 3 different cases in Monroe County where there had been a tremendous amount of media coverage and deaths. I was involved in 2 of those 3. And we did not experience a problem at all at sitting a jury. In fact, I was surprised that many people had not even heard of it in the People versus Clay, which was a highly publicized murder of a young female, Kelsey Bruck. Recently, not too long ago, I had the what would be termed the Boysville murders. And again, I did not have any problem seating a fair and impartial jury. Some had heard of it, some fleetingly. Voir dire, that's what voir dire is all about. That's why we have voir dire. We're going to make a determination whether or not somebody is able to be fair and impartial, what they know about the case, have they made up their mind. Yes, there's been media coverage, some of it courted by the defendants, which is not something you usually see, but certainly not against any of the rules. But for all of those reasons, the motion for change of venue is denied.
Thank you.
You have a motion which has not been responded to.
Your Honor,
Just briefly, Judge, it's
Okay.
people's motion in limine as to the admissibility of scientific evidence. This is a premature motion, Judge. People just wanted to put the parties in the court on notice that this is how we expect scientific evidence to come in, whether it be medical, whether it be in response to the blood result, that people are going to want to see an
Okay.
expert.
Well,
People are
we'll
gonna
address
wanna
it after the witness list come back.
address it at trial, but I just want the parties, the court to be on notice. This is how the people expect it to go, and to not have it come up at trial and bring this proceedings to.
All right.
a halt.
All right.
Your Honor.
I may, I plan on giving all the proper foundation to them
All right.
much prior to the trial date.
We'll cross that bridge when we come to it. A couple of other things. We are going to try this case in Judge Nichols' court. My panel will be coming in on Monday, the 3rd. Judge Nichols' panel, there's 100 jurors in each panel, will be on call for the next day should we need them. My experience has been that that's not been necessary in some of the bigger cases I've handled, but we'll play that one by ear. I have issued an order regarding the presence of the media in trial. This is an order that I've used in the past and complies with the Michigan Supreme Court administrative order. I have one for each of them. Mike, would you give the council that? Anybody from the media who wishes a copy of the media policy may secure that from my secretary, Kaylee. All right. Anything else that we need to address today?
Judge, so just to clarify for the record, the people's motion is reserved until trial. The motion for venue is denied. I pass a proposed order to Mr. Clovis to review, approve for form. The motion to stay proceedings is denied. I pass a similar proposed order to Mr. Clovis to approve for form. The Bene Esse motion is granted with conditions. I'd ask that Mr. Clovis prepare that order for review by us and submit to the court, since it form order won't do, and that we've got a Walker hearing scheduled for February 10th at 1:30. People would ask that media video not be allowed into that hearing, because the court's going to make a determination about the admissibility of statements and evidence. Necessarily, the court may hear statements that wind up being inadmissible, and the people would rather that not be recorded and provided to the media for video on the 6 o'clock news.
I'll stipulate to that, Your Honor.
Well, I'm not going to make a knee-jerk ruling on that. I'm going to think about it.
It's people's request. It's obviously the court's discretion.
All right. I'll think about it. Give me whatever orders you have already and I'll sign them.
Your Honor, the orders that are prepared, thank you. It says approved as to form and content. I'm going to strike the part that says content. We don't agree with the court's ruling on a venue and material necessary witness stand. I'm handing these to the court officer, Your Honor. There's two orders there, proposed orders.
All right, I've signed those orders. Mr. Clovis is going to prepare the order regarding the deposition. We're back here on the 10th. Anything further?
That's from the people. Thank you,
All
Joe.
right, we're adjourned.
Thank you. Have a good weekend.
Enjoy more of our videos on the Community Advocate Network channel, and don't forget to like, share, and subscribe. If you would like to advertise your service, special announcement, or event, you may contact us at the Community Advocate Network at gmail.com. For community resources or services, visit our website at www.canmichigan.com.